Email.
Oh, okay.
Okay.
Well, welcome back, everyone. We're now going to hear from Professor Paul Heaton he's a professor of law and academic director at the Quattrone Center for Fair Administration of Justice at University of Pennsylvania Law School. Professor Heaton's presentation will focus on research into the effects of providing counsel at an arrested person's first court appearance. So we're moving again from our discussion about first stops with police now to the appointment of counsel. Professor Heaton will be giving us a 10-minute presentation, and then there'll be Q&A from the committee. Professor Heaton, it's good to see you. Take it away.
Thanks. It's wonderful to be here. Can everyone hear me okay?
Yeah.
Yes.
Okay, great. So I'm going to talk today about some research we've done on counsel at first appearance. In my written submission to the committee, I summarized a growing body of high quality empirical research that demonstrates that the decisions that are made at the very beginning of the adjudication process, particularly around bail and pretrial detention, have very significant downstream consequences on the guilt-innocence determination, as well as the overall economic well-being of defendants and whether they return to the system. So that suggests it's important to protect due process and have a robust process at the very beginning. I also review some of the case law surrounding counsel at first appearance. I describe some empirical studies, including some randomized experiments, which demonstrate the impact of having attorneys present at the earliest points in the adjudication process. And I also talk about, in the focus of my remarks here this morning, are going to be on some recent research we've done at the Quattrone Center, which thinks about the question of, in addition to just having a lawyer present there at that first hearing, somewhat a warm body in the room, what is the incremental beneficial impact of ensuring that we can have the highest quality possible representation at that point? And so in particular, the research study I'll describe answers this question of what are the effects of an intervention that improves the quality of indigent defense at first appearance. This is a study that's set in the city of Philadelphia. So in Philadelphia, as in many jurisdictions, after someone is arrested, relatively quickly, they're brought via video link before a magistrate, and we do what's called a preliminary arraignment, which combines a probable cause hearing with a bail determination. There is a public defender who's assigned to that hearing. So we have, ostensibly we have counsel there, right? So there is some representation. However, at the time of the hearing, historically, the public defender hasn't had an opportunity to confer with the client prior to that magistration. And so that limits some of their ability to provide high quality representation. So in 2017, the Defender Association in Philadelphia, our local public defender, implemented what they called the Bail Advocates Pilot. They hired some people, not lawyers, but actually people with a social work background, embedded them in our pretrial detention unit where defendants are brought right after they're booked. And the bail advocate's job was to meet in person with people who would be going up for these preliminary arraignments. They did emotional de-escalation. They explained, hey, this is what's going to happen. We're going to have this bail hearing. Often they would call and reach out to family members who may not have known that the individual was even arrested. They had a structured interview where they would collect information that might be used by the public defender favorably to argue for pretrial release. And they also did things like to try and help an individual in the event that they were released to be able to make their court appearances. So things like if it was a drug-involved offense, can we connect you with drug treatment? If it's a homeless individual, can we ensure that when you're released that you have somewhere stable to go to after you leave court? So working with the Defender Association, we did a comprehensive evaluation of the impacts of this pilot. There were two components of the evaluation. We actually got administrative court records covering over nearly 100,000 cases. And we did a statistical analysis to try and measure the impacts of having access to these enhanced services. We also did a qualitative analysis where we did a series of interviews to try and better understand the mechanisms of impact. Now, one of the very unique features of our evaluation was because this was a pilot and the Defender Association didn't have the ability to provide the service to all clients and they were limited in their capacity, they actually deployed the bail advocates only on certain arraignment shifts. And the Defender Association, to facilitate evaluation, actually randomized and shuffled the particular days that bail advocates are available. And so that allowed us to do a kind of gold standard experimental evaluation akin to a clinical trial that we might see in medicine that really allows us to measure very well the cause and effect relationship between these services and what happens later on. So I'll describe briefly some of the key results from our study. A lot of people thought that, well, having these bail advocates, if it does nothing else, it's going to enable people to be released at a higher rate for pretrial detention. We actually didn't see that. In Philadelphia, about 30% of people are detained pretrial. There was a small but not statistically significant difference for those who had access to the bail advocate. However, we did see fairly substantial, statistically significant, and practically very large impacts on other downstream outcomes. So, for example, if we look at the fraction of people who had their bail revoked or forfeited, about 7% under business as usual. When you have access to a bail advocate, that went down to 2.5%, so a nearly 2/3 reduction in that rate. If we look at rearrests during the pretrial period, again, substantial reduction from about 19 arrests per 100 defendants down to 11, on the order of 40% reduction in rearrest. If we actually follow people even beyond the termination of their case, so if we look out a year, 18 months, 2 years after their case is resolved, we also see a reduced likelihood that people actually come back through the system. And again, these differences are pretty large, about a 25% reduction in future contact with the system. We also saw that as a result of having access to advocates, people actually had more lenient outcomes in their cases. The likelihood that a case was dropped or the person was acquitted increased by about 8 percentage points. We also saw that people were less likely to receive probation tails on their sentences, which in Philadelphia and in Pennsylvania is an area of continued concern in our system. I think one of the most interesting findings, we were able to look and see what the impacts of bail advocates were for different racial groups. So in Philadelphia, if you look at the general population of arrestees, 59% of defendants who come through our PDU are Black. If you look at folks who are detained pre-trial, it goes up to 2 and 3. And so we see this magnification of racial disparity as we move further on through the process. Philadelphia has that, as many other jurisdictions in the United States. Based on our experimental estimates, we would estimate that if we were to give those same 100 defendants, 59% of whom were Black, access to services of bail advocates, the detention rate would, the share among the detained that are Black would be about the same, 59%. In other words, the bail advocates actually serve to reduce or undo the magnification of racial disparities that occurred under the normal system. To my knowledge, this is actually the first example of an experimentally validated pretrial intervention that's been shown to reduce racial disparity in this way. We tried to look at what some of the underlying mechanisms were. Why do the bail advocates have these impacts? We point to 2 important mechanisms. First of all, there's evidence to suggest that one thing the bail advocates did was they enabled the defenders to provide more individualized information to the magistrates who had to make decisions about pretrial detention that improved their bail decisions. We demonstrate that in a variety of ways. I think one of the most simple ways that we show that is there are actually timestamps in our data on the timing of the hearings. And we show that when you have access to a bail advocate, magistrates actually deliberate a little bit longer. And so they have more information. They can spend more time understanding the individual circumstances of a person. We also see evidence that there is a procedural justice channel, which is to say that the bail advocates increased clients' engagement of the process. If you step back and think about it from the perspective of someone going through the system, it's kind of alienating, right? You get arrested, you're in this detention unit, brought in a video hearing, you can't hear very well. Your defense attorney, if anything, probably says, be quiet, because they don't want you to say something incriminating on the record. Compare that to a situation where there's someone there, they sit down with you in person, they talk with you, they explain to you what's going on. One could understand how that could affect one's view of the fairness of the process and one's desire to engage further on. And we see evidence to suggest that that's one of the things that happened here. So to summarize, this experimental evaluation of the bail advocates demonstrates that the program improved the pretrial process. It substantially reduced bail failures, reduced future contact with the system, diminished racial disparities. As we think about implications for the important work that the committee is doing, let me suggest that there are a couple of takeaways. First of all, improving the quality of counsel at first appearance can realize broadly shared goals of reducing bail violations, enhancing public safety, diminishing racial disparity, and reducing the system's imprint on people's lives. I think this suggests that policymakers in California should be thinking hard about legislation, rule changes, other initiatives that will promote effective representation at first appearance, not just having a lawyer there, but ensuring that they have access to their clients, they have the help of paraprofessionals. And I know in the next panel, you'll be hearing some more specific suggestions about specific provisions that can be done in California. Thanks. If you're interested in the underlying research, here's a link as well as a link in the written materials. I'm happy to take your questions.
Well, thank you, Professor Heaton. That was super interesting and helpful. I'm going to jump in. So I am curious about the idea that these are social workers versus attorneys doing these. How important do you think that particular pieces? I mean, I can imagine that a lot of the assistance that's provided is uniquely, listen, anybody, lots of people, smart people could be attorneys, lots of smart people can be social workers. So, but it seems like a lot of this work is best suited for social workers. And is that your opinion, or was this a cost saving measure, or if you had to make a recommendation, how would you put that piece in?
Yeah, I think there was a real advantage. It was a conscious decision, so it wasn't about cost. And, you know, the Defender Association said, if we think about the nature of what we're asking people to do, we think it's going to be better suited to folks with that background. And indeed, when we talked to the bail advocates, you know, they talked about, well, hey, you know, people are upset, right? When they're, right, you know, they're going about their normal lives, something happens, they get arrested. Emotional de-escalation was very important. Helping you know, people to feel their voice heard. I think the skill sets, when you ask the bail advocates about the actual nuts and bolts things that they did, seems very well suited to the types of training and the sort of skills that you get in that sort of background. That's not to say that lawyers couldn't do it, but I think that was a wise choice to focus on the social workers. You know, so if I were recommending, I'd probably focus on the paraprofessionals. You know, I have to be clear, right? We didn't directly test the difference between those two. And so, you know, we don't have empirical data.
No,
My intuition is that, yeah, that would be, there's a benefit to having that background.
And can you just describe the process again? So somebody's arrested and then they meet, and then the bail advocate then meets with the defendant, and then the bail advocate works as a conduit between the attorney and the.
Yeah, exactly, right. So they're actually physically situated in the detention unit, and they had a little space, and so they were able to meet in person. They had a structured interview, and they would collect a bunch of information and then convey it over to the attorney that was in the room. The normal rule wasn't to have the bail advocates actually there on the video link hearing, although it was interesting occasionally when we actually talked with people, when a magistrate would figure out that a bail advocate had been involved, sometimes they would say like, hey, let's call this person up, get them involved in this conversation, see what see what they can do. But yeah, it was basically they collected the information, transmitted it to the lawyer in the room.
And are there any other jurisdictions that do anything similar to this that you know of?
I think that, and we'll talk more, I think, when you hear from other panelists. I think there's a huge range of variation, right, from jurisdiction to jurisdiction in the practices here, right? I think it would be less common to have social workers and paraprofessionals involved at this early stage, but there's certainly places that do that. And you can think of a continuum, right? Some places, no counsel at all, right? Some places, Philadelphia, yeah, counsel, but there's some important limitations or restrictions on access to clients, ability to confer, ability to use paraprofessionals. Then we have this model. So I really think, there's no like one single model, and there's certainly, places that don't even have lawyers to begin with, right, constructively at these early stages. So yeah, a lot of variation. And
then I'll hand it over to, is this what you would consider, if you had a magic wand, would you say that this is the model that you would implement or at least try elsewhere? Or is there other things that you would do or different things that you would do?
I think that this is a very strong one. I mean, one could, ask, are there even opportunities for intervention kind of before the arrest stage in various ways? I think, again, I'll be interested to hear what some other panelists say, but I certainly think that, if we limit ourselves to interventions that are available kind of post-arrest, I do think getting people access to counsel as soon as possible, people that can, I hesitate to use the word customer because that's really, but I'll use it because I think we kind of understand, right? The customer experience is really problematic for a lot of folks. And I think being able to do stuff to make people feel heard, make them understand what's happening, connect them with family members in the community early on in this process, I think are all things that are likely to lead to better outcomes. And what the data and the experiment shows here is that indeed in Philadelphia, they did lead to quite dramatically better outcomes.
Neat. Do other folks have questions? Yeah, Justice Moreno.
Yeah, thanks for that presentation. Are the bail advocates employees of a separate agency of the court, of the public defender's office? And if it were the public defender's office, would sort of like a paralegal kind of serve the same function, who was kind of schooled in these kind of data gathering techniques?
Yeah, so they were employees of the public defender's office, and it's worth noting that the norm with the preliminary arraignment is for the public defender to just represent everyone, since it was so early on in the process, regardless of whether or not the public defender would ultimately be assigned to represent them, or private appointed counsel, or a retained attorney. Could a paralegal do it? I think potentially the answer is yes, right? Again, I think if I were designing a model that involved paralegals, I'd want to think carefully about the sort of training and preparation that people get. Because again, I think a lot of the tasks here, obviously, the advocates needed to understand what are the legally relevant pieces of information that could be helpful in that hearing. But, I think they had a structured interview in a way of eliciting that. You'd want the skill set of good interviewing, good emotional, high EQ ways to make people feel comfortable and engaged. I think those are some of the key skill sets. Thanks. That's a great question.
And were these misdemeanors or felonies or both?
Oh, yeah, all sorts. And we saw, similarly positive impacts for different categories of cases, both misdemeanors and felonies.
Any additional questions? Judge Henderson, you're on mute.
Sorry about that. A question or an observation. In the 1970s, California had a student practice statute, and Professor Wall and I taught an 8-unit seminar at the Stanford Law School involving juvenile law, in which Stanford students played largely the role that you were describing, Professor Heaton. They did all of these preliminary things, and Mike kept statistics. He was the scholar there, and I was sort of the guy who knew how to do things in court. But so I don't know what the result is, but does this, I'm just wondering for the committee, does this lend itself, is there still a student practice statute, and could students conceivably play a similar role, do you think, as the bail people here?
So I'll answer that. There is still a student practice rule. Mike Wald is just down the hall for me, so I can get his data from him.
Okay, yeah.
But my preference would, I mean, for a pilot and to study it, I think that might be interesting, but my preference would be to have a more professional role.
Okay.
And certainly to do this at scale statewide, or even just in Los Angeles, I think it would require employees of the public defender.
Yeah. Okay.
Yeah, I mean, if I can just opine, if you look at my written testimony, I do cite a couple of papers and examples. One work by Doug Colbert, Sean Bushway, and Ray Paternoster, which evaluated a student-oriented provision of counsel at first appearance at the University of Maryland using a randomized trial. I kind of agree with the esteemed chair, right? I think that while it's possible students could do this, given the fairly large benefits, I think there's a pretty strong argument for professionalizing this, including this, providing the resources and the capabilities for public defenders or other professionals to be able to engage in this work.
Perhaps they're better than nothing. I mean, that's the other thing.
Yeah.
But anyway, I will get with Mike Wald, and we'll get his data if we can. All right, Professor Heaton, or anybody else on the committee have questions? Perhaps Professor Heaton, thank you so much. The study was really interesting. Your presentation was super helpful. So thank you for joining us. Like I said before, no good deed goes unpunished. I'm sure we'll be back in touch to pick your brain some more.
Wonderful, and thank you all for the important work that you're doing.
Thank you.
Thank you.
All right. So our next and the final panel for today will continue our discussion on assignment of counsel, and particularly when counsel should be assigned. We'll first survey the lay of the land in California, hear about jurisdictions that take different approach, and then conclude the hearing about an innovative and promising early program in Santa Clara County. Panelists, please know that if you have given us a written submission, we have read it. So in your remarks, please keep your comments to 5 minutes and quickly hit the high points so we can move on to our conversation, which is the most important and productive part of the meeting. With that said, our panelists are first Galit Lipa. Good to see you, Galit. Galit is the Executive Director of the Indigent Defense Improvement Division at the Office of the State Public Defender of California. Aditi Goel, who's the Senior Program Manager for the Sixth Amendment Center. Nice to meet you. Judge Juliet McKenna, Associate Judge of the Superior Court of the District of Columbia. Carly Ware, who is a pair team supervisor at Santa Clara County Public Defender Service Office, and David Angel, who's Assistant District Attorney for the County of Santa Clara. So welcome all. Thank you again for joining us. Ms. Lipa, again, it's good to see you. If you could kick us off.
Thank you, and good morning. My name is Galit Lipa. I'm the Executive Director of the Indigent Defense Improvement Division at the Office of the State Public Defender. For those of you who don't know, the Indigent Defense Improvement Division is a relatively new division, and our mandate is to provide training and technical assistance to county-based indigent defense systems in California. Although we're here to talk about a very narrow issue, the timing of appointment of counsel, to understand some of the problems and solutions, it helps to know how California structures indigent defense. California is one of the very few states that has each county design an entirely fund its own system. The result is that 25 counties in California don't have a county public defender office at all, but instead rely on various sort of low bidder contract methods. Interestingly, I'll note that 8 out of the 10 counties that have the highest rates of incarceration don't have a public defender office, and all 10 of those counties are largely rural. So with that in the background, I'm going to make 3 main points. The first is that the failure to appoint counsel in a timely manner is a statewide problem, and it requires a statewide solution. In my written submission, I provide 2 case studies. The first is in Butte County, which is where Chico sits. Because of their court schedule, it's typical for someone who is arrested to be locked up anywhere between 4 to 10 days in jail before even getting a lawyer. That means that if a police officer picks someone up off the street on a warrantless arrest, that individual can sit in jail for well over a week without having anyone to talk to about how or why they were arrested, to advocate for their release, or challenge or preserve any evidence in their case. In Kern County, we have data that shows that over the past 7 years, more than 160,000 people went before judges at misdemeanor arraignment without a lawyer. And in some courtrooms, 84% of those folks appearing without lawyers are pleading guilty or no contest. And what that means is that there are a whole lot of people in California who are getting convictions without any real legal advice or review of the evidence against them. It also means that police practices are not being scrutinized and sort of publicly reviewed on a regular basis. But I want to note that this isn't a problem that's unique to Kern or Butte. We know these issues exist across the state in a variety of counties, big and small, wealthy and poor. We just see a system that's not providing counsel promptly. Second, I will say that none of this is a request to reinvent the wheel. There is already a system in place for prompt representation, and it's the system we have for people who can afford to pay for their own lawyer. In California, if you can hire your own lawyer, there are statutes that ensure your attorney can see you before your first court appearance. They can work to reduce your bail. They can appear prepared at your arraignment. But like in the rest of the country, the vast majority of people who are arrested in California are poor. And for them, there is not a lawyer provided early enough in the process to make any of these laws meaningful. So our recommendations are simply an effort to ensure that all Californians have equal access to their constitutional rights. And those recommendations, as I note, are that authorities report who is in the jail on a daily basis, that attorneys are appointed quickly and prior to a client's appearance in court, that individuals have a meaningful opportunity to receive legal advice before appearing in court, that any plea offer requiring an admission of guilt is conveyed by defense counsel, and that the court should not ask individuals to waive appointment counsel. Finally, in my last minute, I will say that I'd be remiss to not say that we can't just put this at the feet of public defenders, for the most poorly funded element of our legal system, to solve on their own. For meaningful change to take place, all of the system actors need to take responsibility for providing counsel in a timely manner. And as we heard from Professor Heaton, we should strive to make those changes, because this is bigger than just the very important task of protecting individual rights of the accused. But the research and our experience show us is that providing representation as early as possible in the process creates significant benefits for the entire community. Increased compliance with release conditions, decreased use of incarceration, and decreased recidivism, all without increasing public safety risk. So with all of that as a starting point, and I know it's a lot, I really look forward to the conversation and really appreciate and thank everyone for being here for it. So thank you.
Thank you, Galit. Ms. Goel?
Thank you. Good afternoon. My name is Aditi Goyal, and I'm an attorney with the Sixth Amendment Center. 6AC is a national nonprofit, nonpartisan organization that helps policymakers meet their obligations to provide the constitutional right to counsel. In the last 3 years, 2 California counties, Santa Cruz and Lake, have contracted with us to evaluate their indigent defense systems. For California to actually see the benefits of early representation, a system needs lawyers to be present to provide representation, defendants to choose the services of the lawyer and be allowed those services, and those lawyers must be effective. The first hurdle is that there is no one indigent defense system for the state. California requires counties to shoulder the burden of paying for almost all the cost of indigent defense. So while some counties can generate revenue to fund a well-resourced system, others struggle. Some counties may be able to pay for a public defender office, fully staffed with salaried attorneys that have reasonable caseloads, investigators, and social workers. Other counties may not even have enough lawyers who practice in the area. This leaves the 58 counties to create a system that it can afford to pay for, rather than one that is constitutionally required. Every county, though, is left to respond to state mandates that expand the scope of the right to counsel, which brings us to the second hurdle. With no state oversight, California is not aware of how counties are faring. Does every county provide an effective lawyer to every indigent defendant in all types of cases, in all stages in a case where there is a right to counsel? If data shows thousands of misdemeanor cases resulted in guilty pleas without a lawyer in one county in the state, how many in the entire state? I should highlight California is one of only 8 states left in the country that provides no oversight. Despite this variation, the state can place protections to ensure uniformity so that every indigent accused person receives early access to a lawyer, regardless of which side of the county line they happen to be arrested on. 6AC proposes 3 protective measures. The first, the system should not encourage defendants to waive their right to counsel at arraignment. As we saw in Santa Cruz, in misdemeanor courts, there was a lawyer present in the same courtroom as the defendants to provide representation at arraignment. The problem, though, is what defendants heard from the judge and the prosecutor before they chose whether to speak with a lawyer. The judge announced to the group that they first had to decide whether they wanted to represent themselves or have a lawyer. If they wanted to represent themselves, they were told the prosecutor would announce an offer and the defendant could settle their case that day in that one court appearance by entering a plea of no contest or guilty. But if they wanted a lawyer, they could apply for one and their case would be continued for 2 to 3 weeks. Even though the county provided a lawyer at arraignment, many chose to represent themselves. People pled guilty, were convicted, and sentenced in one day without ever having talked to a lawyer who could have investigated their case or cautioned them against serious collateral consequences. Second, the state should establish a transparent, uniform threshold under which a person is presumed indigent to receive appointed counsel. California does not have an indigency threshold. In Santa Cruz, every judge determines eligibility for their own courtroom. So whether a person qualifies as indigent may depend not only on which county they are arrested in, but in which courtroom they find themselves in within the same courthouse. California can look to other states that have developed statewide standards of presumed indigency. Louisiana presumes it at 200% of the federal poverty level, New York at 250%. Both states also presume indigency to all children, people who are unhoused, and anyone on public assistance, institutionalized, or incarcerated. Finally, the state should ensure lawyers are effective at this initial hearing. For this, I will speak to my personal experience as a public defender in Boston, where we represented defendants at arraignment under a statewide mandate. A lawyer is so much more than a warm body with a bar card standing next to a defendant in court. To give effective representation, the lawyer must be qualified, trained, supervised, able to spot legal issues and potential collateral consequences, make bail arguments, be given time and space to have confidential conversations with their client, have access to a social worker, as we did in Massachusetts, who could also assist and fall under the umbrella of the lawyer's confidentiality, have access to the same discovery as the prosecution. Only then can decision makers in any given case, the judges, the prosecutors, make informed decisions that really are in the best interest of the public. We understand that every state is unique, and 6AC remains committed to helping California in its efforts to ensure the right to counsel to all indigent accused. Thank you.
Thank you very much. Judge McKenna, welcome to California.
Thank you. Thanks so much for inviting me. And it's afternoon here, so I'll extend a good afternoon to all of you. I first just want to thank Ms. Lipa, who you all stole away from the District of Columbia. So congratulations to you all for reaching out to me to come and be involved in this important effort. So my name is Juliette McKenna, and I serve as a trial court judge in Washington, D.C. I've been on the bench now for 20 years. The past decade was spent in the criminal division, including most recently as the deputy and then the presiding judge of the division, where I had sort of general oversight responsibility for all arraignment court proceedings. I also had served as the co-chair of the Criminal Justice Act Panel Committee for the past 6 years, overseeing the application and periodic review of approximately 200 private criminal defense attorneys who are appointed and compensated by the court to represent indigent defendants. And so certainly if there are questions about exploring different models of representation, I'm happy to speak to that as well. Just quickly so that you understand the perspective that I'm coming from, in DC, the court relies on a combination of court-appointed attorneys from the Public Defender Service and attorneys admitted to the panel system to represent all individuals at the time of their initial appearance, Monday through Saturday, in all cases. So that ranges from traffic offenses to homicides, as well as outstanding bench warrants. Attorneys are provided with an opportunity to speak with their client in the cell block prior to each case being called, though I would say that in practice, apart from serious felony cases where detention is likely and lengthier interviews are necessary, oftentimes counsel is standing with the defendant and conferring briefly with them about their ability to comply with the release conditions that are being set by the court. I had a chance to review the other submissions, and it sounds like many of us are in full agreement about the overwhelming advantages of having counsel present at the initial appearance. But I just want to say, and obviously I'm biased, but from my experience over the past 10 years, it's frankly difficult to imagine how a criminal justice system could function as fairly or as effectively in the absence of counsel. And so I just want to touch briefly on what I see as some of the main advantages. First of all, I think the presence of defense counsel contributes enormously just to the efficient running of the arraignment court calendar and expedites case processing as the case moves along. The government knows who to extend plea and diversion offers to. They know where to send discovery, if protective orders need to be entered before discovery can be furnished. All of that can get taken care of at the initial appearance. I think it leads to better decision-making on the part of judicial officers. As the professor mentioned, it allows for more individualized and nuanced release conditions to be set. And I think some of the other panelists will speak about the data, and I imagine the professor touched on this as well, about the exponential increase in compliance with release conditions, particularly stay-away orders. And obviously, I think it helps to safeguard important constitutional rights, the right against self-incrimination, and the right to effective assistance of counsel, including preservation of exculpatory or mitigating evidence that could be lost or destroyed shortly after an individual's arrest. And perhaps most importantly, sort of the intangible procedural justice for defendants, in that it increases, what is going on? What is happening to me right now? It certainly increases understanding of the court process, as well as both the perception and the actuality that they are given an opportunity to be heard when crucial initial detention decisions are being made. And I would just note that as a potential alternative to appointing individual counsel in every case, which is what we do in DC, at a minimum, I would strongly recommend that the committee consider the implementation of a stand-in or a duty day type system with very clear expectations being set for the attorneys who are fulfilling that role. And while the DC Superior Court has always relied to some extent on duty day attorneys during the pandemic because of physical distancing and health and safety concerns, restrictions that were in place in the district, we had to go to a system where we were relying almost exclusively on 2 or 3 attorneys every day to be physically present to stand with the defendants in arraignment court. And while it was not ideal, and I think we certainly saw that was far better than having defendants appear before the court without counsel. So I thank you guys for including me from the other coast, and I look forward to the discussion.
Thank you, Judge. That was very helpful. Ms. Ware?
Thank you. Good afternoon, everyone, or good morning, depending on your time zone. I would like to show some slides while I speak. Can you see my slides now?
Yes.
Okay. So I'm a public defender in Santa Clara County. I supervise a team called Pre-Arraignment Representation. And there's 6 lawyers on our team. And what we do now, in addition to just covering the arraignment calendars, is we actually do pre-arraignment representation. I want to show you what that looks like and why we built it. A typical in-custody felony arraignment calendar is shown on this slide. It's between 20 and 30 clients in person in court during the 3-hour session every weekday. And that leaves us 6 minutes per client. We've never met these clients before court. Typically in the traditional model, it's kind of a meet and greet arraignment is how our criminal defense system is currently designed. And during the 6 minutes, we are talking about fundamental, crucial, and very personal details about our clients' lives and families. We're also listening to our clients telling us what they would like to do in the case and legal questions that they have. If they have family members in the courtroom, we're going to take one of those 6 minutes to talk to the family members and get the information about our clients' ties to the community. We might be doing this in another language, either ourselves or with an interpreter. And then we're going to go on the record and do the arraignment and the bail hearing. We're going to present the information we just gathered from these people who are strangers to us 6 minutes ago. And we're going to listen to the judge's ruling. And then we have maybe 30 seconds to explain to our client what happened and what they'll have to do now that the judge has ruled. There's no time in that model to ask the really basic human questions and the basic lawyering questions about how these people are doing and, can we go get the surveillance video and who has it? The reason that we designed the pre-arraignment representation team here in Santa Clara County is really because we see our clients as community members and we want to restore them to their families and to their place in the community, and we see them as full human beings, which is not always how they're treated in our criminal justice system. What we really do fundamentally every day is we just examine information about yesterday's arrest. We talk to our clients in the jail that are in custody today, and we're preparing to appear with them tomorrow at the arraignment, so that out of those 30 strangers, there might be 5, 6, maybe 10 familiar faces where I might have met my client yesterday and I already know the family members and the situation when I come to that court date. I just want to take a few moments to review 3 building blocks that really inform the revisions that I would love to see in the penal code that I submitted in my written documents. The first building block is really meaningful attorney-client access. In Santa Clara County, we have a pretty collaborative culture here, and the political climate really lends itself to asking nicely and getting access to information. So we have the booking lists every day, and we look at who's in custody, and our jail lets us go in as public defenders and just talk to clients. It's kind of an unwritten presumption of indigency. We should write that presumption of indigency into the penal code. Without that access, it's an empty promise that the penal code has all these places where it allows and empowers incarcerated people in the time between their arrest and their arraignment to contact the magistrate judge. There's a judge who's determining bail every day in each arrest and determining whether there's probable cause. In Santa Clara County, that decision is not preserved by the court. It's not filed anywhere in any type of court file. If I want to appeal some kind of pre-arraignment decision that a judge has made, it's virtually impossible to access those records. And it's really a blind system because the penal code doesn't require transparency in the record keeping. That would be a really powerful amendment to the penal code in these sections that discuss what I see as empty promises. In Santa Clara County, we're very fortunate that our district attorney's office really is a true collaborative partner. We have a lot of shared values in our county, and that's not true in every county between the public defender and the district attorney. This is an example of transparency in Santa Clara County. The district attorney's office shares with us every day, 3 times a day, the charging decisions that are coming for tomorrow's in custody calendars so that we can talk to people who were booked on perhaps, a serious case like this. This chart here shows a sexual assault case that was booked as a rape, where that was the accused, the suspected crime, and the district attorney's office, when they reviewed the materials, rejected the case for insufficient evidence. So I am empowered with that information to go speak to that client who's in custody and tell them what's going to happen with the case. And mindful of the time, my final building block is really to, we'd love to see that the collaboration we've been fortunate to just ask for and get in Santa Clara County be enforceable, and that the timelines that the penal code has, for example, arraignment is supposed to happen within 48 hours of the court being open during an arrest, from the time of arrest to booking, from the time of arrest to arraignment. And if someone doesn't get on the list or make it on the bus, or there's a clerical error, right now there's no transparency and there's no enforcement. The penal code should require dismissal of that case or OR release for that case to be litigated without the person's liberty being infringed. And I look forward to the discussion. Thank you for seeing my slides.
Thank you. That was really very helpful. Last but not least, we have David Angel from the Santa Clara District Attorney's Office. Good to see you again, David.
Thank you, Mike. Thank you for having me. Well, I think Carly really covered what we do in our county. Let me just give from a district attorney's perspective, and I think it's a very useful program. And as she said, our interests are aligned. It's good for people to be represented early on. And we do try to work collaboratively with them. While it's clearly a much bigger lift for the public defender's office than the district attorney, I think it's important to fund the district attorney office to do this as well. And part of that is just practical reasons. If there's changes made and all it creates for the district attorney's office is a whole series of new jobs they have to do, but it's nobody's job to do them, there's just naturally going to be a certain amount of pushback for people who are already very busy, who are like, well, why is this my job now to figure out what's happening? By funding a position, and they have 6 for the PD and 1 for us, so it doesn't mean funding it equally, but it allows us to dedicate someone and recognize and telegraph this is a legitimate and important aspect of our job. Where I think that collaboration really helps is, one, structural issues and the sharing of information that Carly just described, and she and her team have brought issues to our attention that we just didn't even know existed, and they're probably time for another set for another time. But just to give an example, we found out through them that there was a time lag between when we dismissed a case and when a person was actually being released from custody. And it was, we then were able to research it and find out that it was mainly just bureaucratic errors and data entry snafus, because we have these digital systems. And once we fixed it, that problem could be solved. So that's sort of an unintended benefit, that you're going to find new efficiencies, opportunities for new efficiencies. The other area where I think it's really helped is we in our office created a new unit. Our acronym for that is CAMP, which is Custodial Alternatives and Mental Health Programs. And basically it's recognizing that more and more of our cases don't really need to be resolved by incarceration and have a strong mental health component. We put PAR, that's Carly's unit, and our counterpart to her under that, because we wanted someone who had an expertise and a familiarity with non-custodial programs and alternatives and mental health issues, because that often is key. Where I think the program doesn't necessarily work as expected, I think that's still okay, but I just want to flag, is when the public defender comes up with new evidence pointing to, in some ways undermining the case. That's not something that really a lone assigned prosecutor can kind of make the decision quickly, by arraignment, because almost by definition, I mean, unless it's a real smoking gun or non-smoking gun, usually evidence is really going to require some consideration. You have to send out investigators. As a practical matter, our PAR attorney really, it's a big deal for them to want to dismiss, let's say, a sexual assault unit case. What we can do is we can be a conduit so that her team can quickly get that information to the supervisors of that unit. But that while that's very important for their representation and maybe downstream a little bit, that's not necessarily leading to a lot of quick releases. But where I think it is more leading to quicker releases is when the public defender is able to mitigate the risks for the judge and for the prosecutor, the public safety risk, by either finding out a new information or finding out issues related to their medication or housing or whatnot, that an individual might not be able to articulate to the judge at arraignment. And more importantly, they may not have actually arranged those changes between the first decision, and we can bring people quickly in for a revised decision, let's say once there's alternate housing in place. And I'll just close with, we recently had one of our first cases where the DA's office actually took the initiative. And we had our partners, which was terrific. And this is a not uncommon situation for a lot of counties and across the country, where we had gotten repeated reports by a very mentally ill, unhoused individual who was very, very threatening. She would grab axes and saws and threaten passerbys, and the neighbors really wanted something done. We all recognized it was a mental health case. We were able to actually contact the PAR unit and say, hey, this person is going to be coming in. Here's what we think the problems are. You know, we hope you can work with this individual so that we can effectuate a release that's not in jail, but also not, you know, going back with some completely meaningless order for this individual back to the community. And they were able to respond and have someone in the court right away. So I think it can mutually solve problems. So I think it's a great program. Obviously, the details of how it should be implemented, you know, are going to vary. But I think the concept is a really sound one, and I'm glad our public defender kind of brought it to our county and brought us in. Thank you.
Thank you, everyone. All right, there were a number of ideas that were floated during this conversation. I just want to try to focus on a few. So I think both Ms. Ware and Ms. Lipa, first of all, talked about information sharing and access to information as being a critical piece. Let's put aside for the time being about when council's point, and we'll get to that as a separate issue. But and I think Galit, you mentioned just who's in jail, like first step, right, should be shared with public defender's office. That's and there's some things that we've also talked about that, you know, are, you know, we're interacting with a number of different bureaucracies here. And so we're trying, and then, you know, we're actually, you know, trying to come in from a state level. It's like, what can we practically impose from a state level? So if you could try to think about things from that perspective. So aside from, I mean, you could imagine a statute that said that, you know, the arresting agency is required to notify or make public, I don't know, would you make public or notify public defenders who's arrested within, you know, X amount of time? But there's other information, Ms. Ware, that you just talked generally, I think, about sort of information sharing. Are there, well, why don't we go to Ms. Lipa first? Is that right? Is that your kind of first step recommendation? And then are there other pieces of information that you can imagine that would be critical to require to be shared between law enforcement? And then would it be public? Is that the best way to do it?
I think that's a good question. I mean, I think as Carly noted, you know, knowing who's in custody is the beginning, has to be the beginning point of this, whether it needs to be entirely public or whether it needs to just be made available through interagency kind of agreement, so that it's notified to the public defender is, I think, up for grabs a little bit. I don't know that there's value in it being like public, but maybe that's the only way to do it. I will note that this is an issue in counties, and I am a little bit of a broken record on this, but this is an issue in counties that don't have public defender offices, and that it is easy to say you have to notify the public defender's office. There needs to be a solution for counties that don't have that institutional player, so that those folks are not left out and are not kind of kept out of the system. I know that, like, you know, thinking back to in Washington, D.C., there was a notification. It often came very early in the morning. I think the same is actually true in Santa Clara as well. If I remember correctly from Carly, it sort of comes at like 2 a.m. or something. There's a list that gets posted, and then you know, we used to have it like posted outside the courthouse door and would come and look and see who's on there and do conflicts and so on. But I would defer to sort of folks who are in the courtroom today to think about how that plays out best. But yes, I think there needs to be some basic information sharing. Otherwise, there's no way to assign counsel early or to get counsel before.
And what
they
information besides, and I guess it also goes to Ms. Ware, besides, okay, John Doe has been arrested and is in custody, what is the other pieces of information needs to be shared?
Well, I think it's really important what the booking charges are, especially in Santa Clara County, where we have a fairly progressive district attorney's office that actually cares about people in the community. Our law enforcement officers will often book people suspected of action for the most serious version of the penal code description for that action. So every theft is a second degree burglary. Every, fight is a, an assault with a deadly weapon or an assault with force likely to create great bodily injury. So everything's a felony at booking. Often when the district attorney's office reviews those cases, they will charge the case as a misdemeanor or a less serious felony. And all of those decisions affect the bail, because at the time of booking, it's actually the law enforcement officer that technically sets the bail.
Right.
Whatever they write on that booking sheet, Penal Code 1269B says that the jail and the court must set scheduled bail. I'd be really interested in seeing 1269C have a really close look at it, because 1269C says that when the schedule bail is up for dispute and the law enforcement agency has asked the magistrate judge at the time of booking to take a close look at the schedule bail, the existing penal code already says that the defendant's attorney, friend, or family member may contact the magistrate and ask for lower than schedule bail. So that sounds wonderful, but there's no hotline, there's no phone, there's no email address, there's no way to contact the magistrate. In fact, this morning I was just trying to do it for a client whose family member walked into the lobby because they had kind of an elderly family member arrested. He had medication and there was information we wanted to share that law enforcement might not have, rightfully included in the arrest documents. And we were scrambling to contact the magistrate. By the time we did, we learned that the bail had already been set. So it's a false promise right now. And 1269C sounds great, and it is great, but it's missing the piece of connecting the lawyer to, or the family member, or the community organization to the meaningful access to the court. And then once the court makes that decision, it should be preserved and documented. There's no record right now in Santa Clara County, and I don't think anywhere else, of these pre-arraignment decisions by the court, because the case isn't filed. So there's no case at the time of the decision.
That seems a difficult nut to untie. And from a state but it seems like the critical piece, just to get back to my original question, the critical piece, who's in custody and on what charge? Like at a bare minimum, every day, the public defender should get that. And it seems like that's done in some counties and several jurisdictions. Mr. Angel?
Yeah, I just want to make I don't think this is a barrier, but I do want to make the point that, there are really strong privacy interests people have in this information. So I don't think it should be a sort of publicly forward document, but there should be some way of getting it to the appropriate agencies. So I think that privacy concern might need to be baked in, or at least considered in whatever goes forward.
I agree, of course. It's the reason why I flagged the idea of public is because, first of all, as Ms. Lipa said, first, there's not a public defender agencies in many counties. Also, families are often the best advocates, and if they're not notified, then, it's all well and good that the public defender might be notified, but so I don't know, that needs to be ironed out somehow, but.
May I suggest one other transparency detail? Yeah. I'm picturing like when you order a pizza at Domino's and then it says your pizza is being made, and then there's this little dot and it says they're putting the cheese on right now. That's more transparent than getting arrested and learning what is happening to your family member, because nobody knows. Okay, they know they're in jail, But you cannot tell from the existing systems, like, are they in jail and the magistrate's right now considering how to set bail? Is the bail already set by the magistrate? Is the district attorney considering charges? Are the charges being, determined and it's a misdemeanor or felony? See, I know those things. Like, I know how the pizza is made, and I can tell families, and there's, 1 or 6 of me on a good day, and 150 people booked into our jail every day. So that's the information. It's like, where is the case in the process? Every other part of our criminal justice system allows that basic information. It's not a secret that your case is set for trial, or that you're in jail waiting to post bail. It's very odd that this most important initial part of detention is not transparent.
Before I keep going, do other committee members have questions? All right. So we're all lawyers here, I think. And I think it fairly obvious, at least to from a lawyer's perspective, reform for California might be to ensure counsel prior to arraignment, right? That's a pretty black and white step. Of course, we heard just previously that maybe even the lawyer isn't the best, most effective advocate for early on. And I was wondering what you all thought either about just a plain law that says, lawyer prior to arraignment, and then how might you, if you think that this social worker idea is a good one, how might that be implemented? Why don't we just start with Judge McKenna? I was wondering, in Washington, in DC, can you explain what by statute, when is attorney present or appointed?
So we do have a lockup list that auto generates every hour. And so the initial that list closes for each day at 10:30. So attorneys are appointed for everyone on the list at 8 a.m. And then when the 10:30 list comes out, the few remaining people who are added to the list in those last 2 hours, counsel is appointed. So counsel is appointed for everybody on that day's lockup list by 11 a.m. Court now starts at 1:30. And so there's about a 2.5 hour window there. We do have a pretrial services agency that then conducts sort of social interviews with each of the defendants in the cell block, just to get basic information like employment, address information, to be able to make their recommendation to the court about release or detention. And I will say, and I think Galit can speak to this based on her experience, I would hazard that all lawyers who go into criminal defense work have a little part of a social worker in them, particularly folks who have dedicated themselves to indigent defense. So obviously, a lawyer is not as good as a social worker in fulfilling those tasks, and a social worker may not be as good of as a lawyer in fulfilling the legal advocacy role. But, I would say particularly for our cadre of stand-in attorneys, they're able to identify if someone's having a mental health crisis. They're able to, gather mental health information quickly to try to be able to connect those folks after the initial hearing with services in the community. So, I caught the tail end of the professor's presentation. I thought it was fascinating, but if there had to be a decision between the two, I would weigh in heavily in support of having that person be a lawyer.
And just out of curiosity, two follow-up questions. The pretrial services that you mentioned in Washington, they work for the court, or they present to the court, or they work with the public defender?
So they don't work actually for either. They're not part of the court, but because we're in the District of Columbia, everything is sort of a weird origin. They're a federal pretrial supervision agency. And so they make recommendations to the court after conducting a risk assessment, their own risk assessment, as to release or detention based upon the individual's statutory eligibility. I will say,
they're an independent actor. They're not part of.
Right. They're a totally independent actor. And, I think the other sort of anomaly is in the District of Columbia, there's just Superior Court. We're not dealing with the challenges that you all are facing with all of these different counties with various systems in place. We also don't operate with cash bail. So, you know, I'm happy to share my experience, but you guys have a big task in front of you.
Yeah, we'll put that,
Yeah.
that's our next committee
Okay.
hearing, next
Oh.
month. You're welcome to join us.
Great.
But again, my second follow-up question, so that's helpful, is what is the timeline for between arrest and arraignment in Washington, in DC?
So interestingly, we take Riverside, your California case, very seriously. We are, from the bench, we are petrified of a Riverside violation, and our defense attorneys hold us to the mark. And so, for example, the auto-generated lockup list that comes out every hour also has the time. It's not necessarily the time of arrest, but the time that the booking was completed. And so we are always on the alert for any case that might be in danger of exceeding the 48-hour timeline. And we do hold arraignment court every day, but Sundays. So court always sits on Saturday and all holidays. And then we oftentimes, if we're in danger of exceeding a 48-hour time frame, we will often convene court early on Monday in order to try to avoid creating a Riverside violation.
Go ahead.
Mike, if I can pop in just in terms of as Judge McKenna noted in DC for the relevance is the lockup list kind of closes and then you get knocked to the next day, but generally it's within 24 hours unless you happen to hit the Sunday. But it's not statutory.
The initial appearance, the arraignment is within 24 hours.
It could be even less than 24 hours. For example, if we were recommending for clients to walk in off a warrant, or we would say, you know, try to get yourself in before 6 a.m. because then you'll get seen the same day because the list won't have closed yet. You'll have gotten booked before that 8:30 list and you'll be seen that afternoon. So you could avoid potentially a night in jail at all. So it's a far more, I think it's a far more efficient process in that way, even though I will note that it is, you know, a large superior court system. It's not you know.
Right. No.
But it works fairly efficiently, far more efficiently in that way. And I think it is because of this regular kind of communication that happens between the courts and the marshals and the lawyers. Everyone kind of has information in real time and is able to adjust in that way. And if I can just on the issue of the lawyers and the social workers, just to go back for a second, I think the real importance is the kind of appointment. Who the offices decide to sort of send in to do the work, I think may depend a lot on that particular jurisdiction's ability to hire certain professionals. You know, certain professionals are harder to hire in certain counties than others. What sorts of programming and needs are needed by that county? But I think the importance is to start the appointment process so that someone has to be a bit, you know, doing the work. Whether for a particular county it makes more sense. You know, if you don't have any programming or if you don't have any sort of social services networks in your county, it might be more important to send in a lawyer to make the legal arguments because there might be less work for a social worker to do, sadly. But if there's a lot available there and a rich connection of social services, maybe it makes more sense to do a social worker, maybe it makes more sense to do, some other paraprofessional. But I think that starting point is the key.
And now, so just to make sure, again, to try to distill down for this sort of higher level conversation. So it seems like the information sharing that we were talking about earlier about who's in custody for what charges, whether or not it's public, we'll reserve that for another day. But then appointment of counsel, and then you would say prior to arraignment. And then let the public defender agency, however they want to manage that relationship, leave it to their own self.
Yeah, but if you're not appointed, as Carly did that like amazing presentation of, if your 6 minutes begin, in the court in front of the judge, there's just no way you can do a good job. Your time needs to begin at some earlier point.
Right. No, I know, but how would you specify that?
I think you would need to put in a time period.
A time within 24 hours of arrest or something like that.
Mm-hmm.
Got it. Ms. Goel, I was wondering, given your observations, especially, I guess you guys were really monitoring, was it Santa Cruz was your,
Yeah, Santa Cruz that's right. Mhm.
yeah, and it sounds like there's some horror stories there. We can't solve every problem, right?
That's right.
And with it, keeping in mind that the perfect is the enemy of the good. I mean, how would these be among the top priorities, or would you refine them in any way or add?
I think to go to the social worker question earlier, I think what I took from the presentation by Professor Heaton was that the social workers were there to assist the lawyer, right? They were there to be able to obtain information from the defendant and then relay it to the lawyer. And the lawyer figures out what is an effective bail argument to the judge, because the lawyer is trained to do that. I think also what has been mentioned before is that if you have lawyers who are trained to obtain that information, and if you have lawyers who have time to obtain that information, that's really, you don't need the social worker to do that, right? So in Massachusetts, we had social workers present in court with us to assist us if we said, hey, social worker, we need help here to obtain, a bed or to see if there are services out there. I think you want the lawyer to be, in my opinion, you would want the lawyer to be the first one who interacts with a client, right? You don't want to reduce the standard you don't want to reduce the standards of performance here as to what's really required to have a client-lawyer relationship and to make effective bail arguments. The earlier the appointment, the better, right? I think that's very clear. I think the earlier the appointment, the better. And, as we saw in Santa Cruz, I think my caution is, even if you have that early appointment, it can't be difficult for defendants to say, I want to have a lawyer, right? If you can have an arraignment within 24 hours or within even 5 hours if you want to. But if the system's going to be operating in a way where defendants are saying, I'm opting out, then what's the point, right? So there has to, I think there was a recommendation put in the submissions that the plea offer, if there is one made, that it be voiced and relayed by the defense attorney or by the appointed counsel. I think, Galit, that was your recommendation. I think that's a great recommendation because it prevents sort of other system forces that are there, because it's tempting to have misdemeanors get resolved efficiently because of the volume of cases. And you want to prevent people from waiving their right to counsel easily, is what I would say.
Judge McKenna, I just wanted to clarify one thing real quick. Everybody who's arrested, is it presumed that they need a public defender? Is that when you say you appoint, everybody gets appointed? Is that how it works?
Yeah, so I mean, I think it sounds like similar to the population overall in California. I think probably 99% of the defendants who come before the court are financially eligible. I believe our cutoff is 200% of the poverty level, but I would have to, if it's not 200, it's 250. But we err on the side of appointing counsel for everyone at the initial arraignment. They then undergo a financial eligibility interview. Pre-COVID, that took place prior to arraignment. But even if it turned out they were financially ineligible, we would still have the duty day or stand-in attorney represent them at that initial presentment. During the pandemic, obviously, we had to forego the financial eligibility interviews, and there really was no difference between the number of people who would have qualified for counsel.
All right, I'm just curious about that. Ms. Ware, and this might also go to Galit. So although we try to make recommendations that are, we don't want to look at the price tag. We want to make advise on good policy and let wiser heads prevail on that. Our member of this committee, Senator Skinner, she's the chair of the budget committee, so I'm just going to ask on her behalf. So you said you have 6 attorneys in your office, in your department, and is that? I mean, I know everybody could do with more and whatnot, but is that I just wanted to know what percentage should we expect the public defender offices in particular, and David, this might also go to you, is if California required basically the services that you provided, or at minimum appointment at arraignment or prior to arraignment, 24 hours, let's say, how much of what percentage of how many additional attorneys are we going to have to hire to do this?
I would answer that in terms of visualizing a calendar. So in Santa Clara County, we have about between 50 and 60 in custody defendants per courtroom every session. It's a pretty high volume calendar, and we'll have 2 lawyers. We usually have 2 defense attorneys from the public defender, 1 for felonies, 1 for misdemeanors, and 1 district attorney on a calendar like that. And so I would say for each lawyer on a calendar, you're from the defense side, you're going to want an equivalent lawyer pre-arraignment, because it's really hard to do both. And you need to switch off. So in the way I've designed our team is that we used to just do all of our arraignment calendars as these meet and greet stranger arraignments. And now I have 1 attorney every day, and sometimes an investigator, a non-attorney as well, doing pre-arraignment interviews every day. So we have 6 attorneys, 5 are in the courtroom, and 1 is doing some kind of interviewing. And I'd like more than that, but we have to cover the courtroom.
And you cover the whole county, the 6 of you?
We covered all the felony cases in one of our 3 buildings here in the county. It's the main central hall of justice.
So it's not even covering the whole county, even for felony?
Not even covering the whole county.
And how many attorneys are in the public defender offices?
About 100 attorneys overall.
David, I saw your hand was up.
Well, I just going to say, I think it's, I hate to say this at the end of a long thing, but I think it's just a very tricky question, and it needs some thinking about, well, what is it we're trying to achieve, right? Because in some ways, maybe you don't need anyone more, which sounds crazy, but what I'm saying is all you're doing is shifting the timeline, right? Well, you're doing the same work, presumably pre-arraignment, that you were doing post-arraignment. But then it brings a lot of really complicated questions, like, well, where are you supposed to meet your client if you're a public defender? I mean, in the jail, like, it might be the first, and do you want this for everyone, or do you just want people in custody? Probably just people in custody, because, if they're not in custody, then the timing isn't quite as urgent. So this might almost, I don't know if this is the purview of the committee, but this might be one where it would help to have counties pilot this to kind of figure out what's effective. I think what Carly and her team is doing, even in the 6 minute, is tremendously effective for certain things, because obviously you have more than 6 minutes after that one moment in court. But if you really want, everyone met by a different set of legal team prior to it, I think it could get pretty major. But if we give counties, I think, some flexibility on how they're going to do it, and we can see what Carly and her team has done, then I think you could probably make an intervention that's not quite as overwhelming and probably a non-starter in Sacramento would be my thought.
Galit, have the public defender office done any thinking about this part?
Well, one thing I will say, and I don't, I raise this with caution because I do, but the state of California does not pay for any piece of the county's indigent defense system. California is one of the only states in the country that does not provide any funding for indigent defense. So while I have thoughts about whether it should be that way, I will note that we would be asking, I suspect we would be asking the counties to carry a burden, a new burden,
Right,
in addition to their work, with that may or may not come with state funding, since no other piece is currently funded. Given that, it may be worth considering a state pilot program in a variety of counties, including counties without public defenders, to see what are the benefits and what are the long-term cost effectiveness. Because we can imagine in a world where sentences are shorter, where people are being rearrested less, where the better decisions are being made about who needs our custodial beds and who doesn't, that there is cost savings to be had there, cost efficiencies to be had.
Oh,
there.
yeah, I'm sure, but don't get anybody started on that.
No,
They won't
no.
let you count those.
I know. But I'm just saying, it may be worth thinking about kind of how those costs are, who's paying for those costs and how they're shared or not shared across the county.
No, sure. And your point is well taken, that the state doesn't cover any of these costs and it would be an imposition. But then there would be huge, but the reluctance in Sacramento would not necessarily be from the state budget, but from the, from the counties themselves. That would push back. All right, I've exhausted my questions. Is there anybody else on the committee who have questions? All right, with that, we're gonna take a quick lunch break. Thank you all. I really appreciate, there's a bunch of you on this that I've known for a while, so good to see you all. Thanks, you've given us a ton to think about. This is obviously a really complicated area, but I do think that there are some, at least initial reforms that really should take place. And thank you all for your time, and it's good to see you again. We are going to take a lunch break now. Tom, what's the best time to reconvene?
We're not relying on panelists, so whatever works for the folks on the committee, and we could sort of do an hour maybe, or come back at 2, whatever you think, Mike.
Sure, let's come back at 2 o'clock. Thank you all. At 2 o'clock, we'll be going over administrative matters, including a legislative update on bills that are currently pending before the governor, actually, from recommendations that we've made. We'll discuss this morning's panels, try to refine some of the ideas for further advice for staff, and then we will return to some of the issues that we've discussed at prior hearings to further refine those ideas. So with that all said, we'll adjourn until 2 o'clock. Thank you all. It's good to see you, and I'll see you too.